Hello, everybody. This is a important update regarding a case that came down in California in federal court. Really important because it really emphasizes why things are so difficult for investors in California and why they're flocking to Indiana and other states. Um, I've heard many times, and perhaps you have anecdotally, that it's difficult to be a housing provider in California because of the eviction rules and whatnot. I've never had to deal with them, but this case is a very groundbreaking case and demonstrates why things are so difficult in California and why investors are coming here and why they should come here because it's just ridiculous. So this case came down out of federal court in California. I don't have a site for it, but it's Better Housing of Long Beach. Um, is the plaintiff, so you might be able to find it that way. It was reported actually on Fox News, which doesn't normally report legal things that I get as a matter of course. But what happened here is that the legislature of California has enacted a number of very pro-tenant statutes limiting your ability to evict a tenant under lots of circumstances. And in this case, you even, as a housing provider, you may even have to pay your tenant after you evict them. So you've evicted them and you still might have to additionally pay them money, a month's rent, for them moving forward to their next location. And this statute was enacted in 2020. It's been embroiled in litigation, and the housing providers lost. The Court of Appeals said, yes, we're going to hold this statute as being valid and being constitutional. The next step would be to go up to the Supreme Court of the United States to decide it, but it's one of these takings cases where the government is preventing you from evicting a tenant and then taking money from you further by forcing you to give it to the tenant. And some of the background statutes, and I'll put the sites on here when we post it, talk about House Bill or AB 1482, the California Tenant Protection Act, and it requires a housing provider to have quote unquote just cause before you can terminate a tenancy. So just cause is defined in the statute, and you have to meet these different statutory thresholds. And if you don't, then you are violating the statute and you can't evict your tenant. Now, of course, the number one reason for evictions is non-payment of rent. And that is a cause, a proper just cause for evicting under this statute. But it has all these other little loopholes in it. The other thing is that the statute provides that you cannot have rent increases of more than 5% plus the consumer price index locally. Now, locally, in the case, talked about San Francisco CPI was officially 3.8%. Well, we know that nationally, what we're seeing is 8.5%, 7%. So California is not only capping the rent increase at 5%, but they're capping the consumer price index as their local number, which is completely, shall we say, up to their discretion of what they're giving you. So in a high inflationary time period like we're in, housing providers are getting hit even worse because they're not even allowed to increase rent that's consistent with consumer price indexes. So there's all this very difficult loopholes that you have to jump through. And they even talk about what I want to call, in California, they have evictions for what's called no fault. So if you just want to have a 12-month lease and then terminate the lease as normal, nobody's done anything wrong. The housing provider's done nothing wrong. The tenant's done nothing wrong. They're just terminating the lease according to its terms. That's not permitted necessarily in California. You can't just say, hey, your lease is up, you're out. They're automatically sort of renewing it against you. And there's all these provisions in their code that prevent you from just terminating it unless you're moving in, or maybe you're selling the property and the new buyer is going to move in as an owner-occupied residence. So there's all kinds of different things in there in this manner that are very difficult in California. And it's not a surprise that landlords and housing providers are moving their capital out of California There's lots of exceptions. And I'm just giving you a few examples in these codes of why it is so difficult to do business in California as an investor. And I would think long and hard about investing in a state like that, because the hoops you have to jump through, the procedures you're going to have to jump through just to get your property back are very difficult, and you might even have to end up paying your tenant after you evict them, which is staggering in its own way. So I invite, if you're a broker listening to this, we got a lot of brokers on this that see our videos. You should be marketing to people in California, because they got to get their capital out of that state and into other places that are more friendly towards business and towards investors, like Indiana and Florida, other places like that. So be careful. If you'd like to take a look at the statutes, read them. They're exceptionally complicated. And some of the blogs that I read were, here's some general information, but if you want to really ask us a question, it's a paid consultation. As you know, we give a lot of free consultations, but in this kind of a scenario, if I was a California lawyer, I'd be saying you have to pay to get the kind of detailed advice that you need, because the statutes are so complicated and they refer over and over and over. One statute refers to another, to another, to another, and there's definition after definition. It's the height of bureaucracy that makes practicing law difficult, getting justice difficult, defending your territory difficult. So interesting case. Check it out. Again, it's in federal court, and the plaintiff was Better Housing of Long Beach. Try to find that, and I'll give you some statutory sites as well. Good luck, and welcome to Indiana. It's a great place to do business. We're happy to have you here. Thank you.